think we are sort of at least as complete as we should be for 5 o'clock in the evening. So it's my very great pleasure to introduce yet another very honorable speaker here with us today, Manuel Desantes, and he's going to talk essentially about the future of European, and I'm particularly not saying EU patent law, but the European patent law. And I think, well, there's lots of information about Manuel, what he has been doing and what he is doing at the moment, primarily, of course, being a professor in Alicante, but I think the reason why he's particularly apt to give this talk is because he has been involved on the national side, on the EU side, and on the intergovernmental side in relation to this whole European patent project. So Manuel has been with the EU Commission long time ago, but he has been with the EU Commission for quite a while. He has been Vice President of the European Patent Office, which, as you know, is not EU law or not an EU institution, and he has also been, especially as someone from Spain, deeply involved in these sort of different processes which lead to questions about what countries join the UPC, the Unified Patent Court, and how the whole process of European patent integration is moving forward or not. And so he's here to talk to us about the future of European patent law. And Manuel, I thank you very much and leave the rest to you.
Thanks, Ellie. Good afternoon. Thanks, man. I'm going to discuss with you a topic which fascinates me. It's more than 30 years I'm involved with law, basically. Believe me, I never ever found a topic so rich and so impressive. Probably because it's so miserable at the same time. So my purpose today is to bring you on board. I'm going to talk to you, each of you, and you are not going to lose a single comma. We will start with another tool where you will have some work to do, reading, bringing yourself on board. Then we will come to the what and the how, and then we will come to the what and the why, first mistake, yeah? And then we will come to the how. Then I will try to agree with you why this is so fascinating from a legal theory perspective, and then we will come to some conclusions. Are you happy with that? That's it? Okay, that's it. Well, it is the first time ever the President of the Commission, former President of the Commission, said this. One of the weakest points of my term. It is the first time ever that the Council of Ministers of the European Union, here you have the Council of Ministers of the European Union, the President of the Council of Ministers, this time was Belgium, made this statement. Read this statement because it's unique. You will not find a statement like this one. By the way, all the reading, you will have it online, yeah? I will send you, not the pictures, but all the readings, yeah? Of interest. So read this, please. Every single word thoroughly thought. We have come a long way. It refers to 53 years negotiation. Most delegations have shown greater flexibility than ever before. So others didn't. Yeah, you see? Good. Because the Council understands the importance of securing a European Union patent system. As we will see later on, European Union patent system becomes one of the cores of the future of the European construction. We have left no stone unturned. Did you hear about the enhanced cooperation? Enhanced cooperation is a process which was brought by the Germans, basically in the Amsterdam Treaty, because they were extremely unhappy with the possible situation that for political reasons, the Eastern European countries were going to join massively, and they were not going to be ready in most of the cases, bureaucratically, standards, not getting the right position, to agree on a certain number of directives and regulations. The risk was to stop the European integration for a decade. That's why in the Amsterdam Treaty there were 10 articles dealing with this enhanced cooperation, which was thought to be massively used as soon as the Eastern European countries joined. What does it mean? It means that in those cases where unanimity is requested, and this is the spirit of the enhanced cooperation, when it was brought by the Germans, basically. In those cases where unanimity is requested, and it is not possible to achieve this unanimity, not because they are two different visions, but because some of the states are not in a position to join, because they need to change their laws first, or they need to change their uses first, or they need to change the bureaucracies, yes, or to standards, yes, or whatever, then it would be possible to put them aside for a while. Those who can go, they will, and they will invite permanently the others to join. You see the mechanism? Yeah? Why? Always why? Ask why? Why? Not to stop the development of the European integration. Did I explain myself correctly? In order to be able to move into the enhanced cooperation, this has to be the last resort. So you have to show that you didn't leave any stone unturned. You did your best, and there's no other way. Enhanced cooperation was not used, as the Germans thought, massively, basically because the newcomers did their homework quite well. And it happened that it was used first time for the law applicable to divorce in 2012. This is the second time, and now there's a third occasion with the Tobin clause, which means that every financial transaction will be charged. By the way, the United Kingdom brought the Council to the Court of Justice because of this. Same way Spain brought the Council in front of the Court of Justice. We have left no stone unturned. You see the reason why they put it there? In order to open the possibility of an enhanced cooperation. We have fallen short of unanimity by a small margin. You see this diplomatic way of saying Spain and Italy didn't join. Why? Say why? Why? It's easy to explain. Because there is a principle of EU law which does not say that all languages request the same treatment. This is not a principle of EU law. The principle of EU law is if you discriminate amongst the languages, you have to do it through unanimous decision. You see the difference? Yeah? So Spain and Italy were not happy with the way this EU patent was coming. We will see why. Basically because the languages proposed were the languages used by the European Patent Office. English, German, and French. And then as a result of that, they didn't agree. You see the difference between what was thought before, how enhanced cooperation should come. No controversy, but technically, let's say, problems, to this enhanced cooperation, where, in fact, we have two visions. All in all, at the end, what Spain did, let's record it. What Spain did, I would say, you should never change the strategy when you are in the middle of a war. You change tactics, but not the strategy. The very moment Spain realized that the Commission was going to propose English, French, and German, and point basta, then Spain changed the strategy and brought a document. This was end of August 2010, brought a document in front of the Council, which was a declaration of war. It's so fascinating. A declaration of war, because a declaration of war against France. It was a very basic document. Question was, why do you limit the languages to 3? Why? Because of the cost of the translations. Okay, then why to 3? Why shouldn't we bring it to 1? And then this is the English-only approach. As this paper arrived to the French Senate, and when they say it's public, you could see it in internet, what happened this is the beauty of internet, yeah? You can see it in internet what happened in the Senate, the French Senate declared the war, take over our body. No way. Just because we Spaniards and the French have, let's say, the same beauty and the same problem. What we have is our language. That's it. As a result of that, right away, so 2 months later, this document came. Do you understand now? Did I explain myself why the issue came? So fascinating. First time ever, the enhanced cooperation is used in a situation where there is a real conflict. Spain brought the Council to the Court of Justice, and the Court of Justice dismissed the claim 16th of April 2013, saying it is possible to use the enhanced cooperation even in these cases of controversy. Which means that opens a beautiful path for future enhanced cooperations anytime someone disagrees. Think that you need 9 countries for an enhanced cooperation. So theoretically speaking, you can open 3 enhanced corporations for the same issue. 9 per 3, 27. Now they are 28. So look at these guys. They're looking for something. They're looking for something. But these guys, so European Council. This is not the Council of Ministers. Before this was the Council of Ministers, yeah, which is an institution of the European Union. The European Council, which is another institution of the European Union, which is composed by the heads of state and chiefs of government, which by law is in the treaty. They are forbidden to take decisions, to take legal decisions. They orientate the politics and the strategy. They just cannot. They never did it. Never ever. I have taken the time to bring since the first meetings in the 70s. It was not called European Council then. It was the Sommet Européen. Yeah. Since then, I have taken the time to read all the different conclusions. Never. First time they came with something like that. It's so fascinating. Look at this. We suggest. Funny. Why we suggest? Because they cannot decide. We suggest. Now, when you both suggest, what do? You just obey. Oh, we suggest that these 3 articles of the regulation, so of the EU patent regulation, yeah, be deleted. Because these 3 articles contains all the substantive patent law. and it was taken out of the regulation and brought to another place. We will see what is this place and why. Fascinating, yeah? Ever before. Are they looking for the EU patent? Then they came to an agreement. Yeah, so they have an agreement. Look, beautiful, after 50 years, we have an agreement. So this agreement, which is called the unitary patent, we will see that's not true. There's no such a unitary patent. Yeah, I will not use this name, because in fact this name is a European patent with unitary effect. This is what people call unitary patent. We'll need to consider reduced costs for SMEs. SMEs? You think it's really SMEs that are going to use this system? Anyway, boost to innovation, providing affordable, high-quality patent in Europe with a single specialized jurisdiction. Yeah, see, this is the politics declaration. Ever before, here they are. But they didn't bring a European Union patent. They brought a European patent. But this is something we had it already, the European patent granted by the EPO. So this is a kind of European patent. And we will see then why it was not possible to bring an actual European Union patent. You know why? Easy. Because for having an EU title, you need a 28. There were two who were not very happy with the situation. You remember? They started an enhanced cooperation, the other 26, but this cannot be called EU patent. It is not an EU title. So they had to change the terminology and the consequences. And we will see what are the consequences and why. Good. Fascinating. Look at the guys. Look at these guys. They are ministers, except one. There's one who is not a minister. This tall one, former Commissioner Barnier. You go to internet and you put in Google something like signature of the Unified Patent Agreement, you still find, not in the website of the Council, because it was deleted, obviously, but you will still find in other places where it have been replicated, at the very moment when the family picture was going to be taken, then suddenly a voice appears on the back saying, "Do you allow this commissioner to be in the picture?" I've been working for quite a amount of years for the European Commission. I thought the European Commission is the motor, is the European Commission is the promoter, European Commission is behind, European Commission is there. Well, here, what we found is that member states arrived to an international agreement outside the European Union law. They were going to take the picture, and then the commissioner asked for permission to be in the picture. Which brings us to the last of my conclusions today, which is a fascinating one. This is the most remarkable piece I have found to show that in this roundabout, which is the European construction, so glorious and so miserable, we are now down. And we're certainly moving into a phase where we move from institutional to intergovernmental. And I will show you there. So fascinating, yeah? So why this is an important matter to you? Now, do your best to read this case. This is an Arnold case, an Arnoldian case, yeah? Arnold, you know who is Arnold? You should know, if you know something about IP, you should know who is Arnold, yeah? We used to have other very good judges in the United Kingdom. Now it's Arnold. So Arnold gave this Arnoldian judgment some months ago. This is Lilly, and there's an American company who, and this is Actavis, who is an Irish company with a generic. So So you have the pharma company and the generic, all the big guys. This is the molecule in question, penetrated dissoluble. This is what was claimed in the European patent. Quite important, because this is the only drug in the market. It is commercialized with the name Alimta, which identifies cancer cells and non-cancer cells and impede the growing of cancer cells. Quite important for all the metastasis people. This drug has saved a lot of lives already, and it's still under patent. It will come to a certificate, supplementary certificate, very, very soon, and Actavis wanted to start preparing the commercialization of the drug. And then, when they started, they realized that this was what had been claimed in the patent. When you draft a patent, you have to be very careful, because this is what it was claimed. Well, then it happens that with other pemetrexate, which is not pemetrexate disodium, for instance, with dipotassium, with ditrometamine, you always can get, even with the acid, you can get the same result. The question is what do you protect? You protect the pemetrexate, or you protect the disodium? With millions and millions behind. And, most of all, the possibility of getting the Amilta right away to the market as a generic. You see the importance of the case? Good. Then Lilly brought Actavis to court in Düsseldorf for infringement of the European patent validated in Germany. And then Actavis brought Lilly to court, London court, asking for a declaration of non-infringement. This is a very, very special case for those who are interested in private international law, because Actavis asked for the declaration not only in the United Kingdom for the UK, for the patent, European patent validated in the UK, but also for the patent, European patent validated in Spain, in France, in Italy, and also in Germany, then withdraw in Germany. Well, what happened is that 3rd of April, the Düsseldorf Regional Court condemned Actavis. And then some days later, 15th of May, Judge Arnold declared that what Actavis was doing does not constitute direct infringement in any of the other places. This very day, Lilly fell down 2% only for that. What a mess. Take the second case. This is an invented case now. Yeah, it's Ronaldi versus Messi. Just read it. Read it for 20 seconds, just to come to the conclusion that if you face something like that, this will be the case of your life. It's so complex, the present system. It's so complex, the present system in Europe. And if we don't have a European Union patent, this is the result. The result is a complete mess in Europe. So the European Union has a problem. Do you agree with me? This first conclusion? Yeah, has a problem. Well, voila. C'est le problème. Yeah? So we will see the why, the what, the why, and the how, and I will bring it into 5 journals. And at the end of the lecture, we will come to 5 conclusions then. Yeah? And basically, I would like to give you some ammunition to deepen into these 5 possibilities, which goes much further than the patent law. Well, 30 minutes from now. Promise. So let's go to the first act, the what and the why. This is what has happened. So please grab it, take it, pay attention. First thing which has happened. We were supposed to have a European Union patent. We came about the European patent with unitary effect. Why and what is the difference? We were supposed to come with all the member states on board. But we came at the end with an enhanced cooperation where Spain and Italy are not there. Why and what are the consequences? We went to the European Union Court since 50 years ago, and right at the end, member states decided that they were not very happy with this, and they created an international court, first international court in history, dealing with private law matters in such a way. Isn't it fascinating? Really? Oh, that's great. We were supposed to have a substantive EU law, and we moved into an agreement outside the EU law where we had there the substantive patent law and not within the EU law. I'm not judging, I'm just saying that there are consequences. You know what is the main consequence for that? If you have substantive law being EU law, who is the only body who has exclusive competence for the interpretation of EU law?
Court of Justice.
The Court of Justice. But you will say now, who is?
Sorry, the Court of Justice.
Yes, very good. Right. Great, thank you.
Thank you.
Very good. Well done. Well done. But if this is not under the EU law umbrella, but in an international agreement, ratified, signed and ratified by the member states, then the Court of Justice is out of the game. Huh? Well, and finally, we move, and this is the most important conclusion for you, we move from the European Union environment to European environment. Is this the same? What do you think?
Yes and no.
What is European Union? It's 28 member states and international framework. Yeah? What is Europe?
Big.
Who knows?
Abstract.
The 48 member states of the Council of Europe, for instance, OECD. What is Europe? What is Europe? Yeah? 38 member states of the European Patent Organization. Is this Europe? Certainly the concept is completely different, is dramatically different. You agree with me? Let's go to the first, very quick. I'm going to do the next 3 minutes, 4 minutes to do an exercise which you didn't expect, probably. First question is, if we move into an EU patent, this means we need an EU patent. Why do we need an EU patent? I will not go many times to that, yeah? But I think with this you have enough ammunition. Today, patent is purely strategic. The only future for my country, I don't know for you countries, but certainly for my country, which is in a very deep crisis, the only future is innovation. My country is a country composed by almost 40 million people, very creative. Believe me, yeah, we're Spaniards, we're very creative. But we just don't know how to bring this creation into innovation. One thing is the creation, another thing is the innovation. What do you protect in intellectual property? Should you protect creation or should you protect innovation? Well, perhaps we should change the paradigm completely. If I write a book and I put this book, now I'm talking about copyrights, and I put this book into self and I close it for years and years and years, well, what does it mean for society? When the hell it should be protected? If I invent something and I don't bring it to the market, why should it be protected? Intellectual property is not more than a tool. I'm provoking. We human beings have invented to accompany, to bring, to get the oil from creativity, from creation to innovation. So today a patent system is key for the development of my country, for the development of Europe. It's part of the EU construction. If we don't have a European Union common policy on how to use this machinery, which is called intellectual property, then we will never get an internal market. We will never get a really competition law fairly applied. This is my view. So what should be the characteristics of this European Union patent? A European Union patent should form part of a system. What is a system? What do you think is a system? What is a system?
A system.
System.
Something that is coherent.
Something which is coherent. Very good. Something else? Well, I think that if we jurists, I couldn't say lawyers, if we jurists, or we try to pretend to be jurists one day, the very, very word would have to be here day and night is system. Law is a system. So what is a system? Coherent. Very good. Something else?
Clear.
Clear. Now, what is the very essential characteristic of a system? Without this, you don't have a system.
Predictability.
Predictable. Very good, yeah. And because all these are adjectives of a very essential concept, which is completeness. A system is something complete. If it is not complete, it's not a system. Point. So if a system is something complete, a body of rules, a body of users, a body of whatever, which gives you the possibility of ordering something, put it into order, that's why it's legal order, yeah? On a given subject. This is a system. Please be systematic. A jurist is a person who is systematic. Jurist equal systematic. That's it, very easy. Okay, if this is a system, then, and this is a legal system, I wonder, and it could be different, but I wonder what are the very essential characteristics of a legal system. You need first an empowerment, so you need state behind, or authority, an international organization behind. You need a body of rules, of uses, able to give an answer to all possible questions, and you need the power to enforce. Well, let's put it like that. Don't go further, but this is the basics, yeah? Let's apply this to the EU patent, to the patent system. Let's apply it to a national patent system. This gives us 6 characteristics. You need an authority that empowers. Yeah? You have it in the national patent system. You have it. Yeah? You need a granting patent office and a granting process. You have it. We have it in the national patent system. Correct? If not, tell me. Yeah? You need a title. This is a sovereign right. A patent is not a monopoly. A patent is not an exclusive right. A patent is a privilege. It's a privilege I, society, decide to give it to you, inventor, or patent holder, yeah? Because you have brought me something which merits and which is very useful for me, society. This is a patent. Because of that, I limit my sovereign rights and I give you the possibility of being the only one bringing this into the market worldwide. And that's it. But that's it. That's it. So you need a title. And behind this title, you have an empowerment. This title should have unitary effects. In all the territory, the same effects. If you abandon it, for the whole territory. If you limit, for the whole territory. Yeah? Is it true? This is the unitary effect of a patent granted by any national authority. And what is essential is you need an autonomous effect. Which means, be very attentive here, please. Because this is so strategic. I, state, society represented, I want to be the only one who controls what are the rights and limitations which I give to you. Of course, I can agree in an internationally with another colleagues, but I want to do it myself. This is the principle of autonomy. I could never say, well, imagine you have the president of the Spanish government and say, well, the effects and the limitations of the title I grant, which limits my sovereign rights, Lionel, will be ruled by Guatemala's law or by US law. Do you think this is consistent? Well, this is not consistent in my view. And finally, you need courts able to apply this, to interpret this, and to enforce it. You agree with me? Well, that's a national patent system. So that's why national patent systems exist. Do we actually have a European patent system? A European Union patent system today? Let's see. Do we have an authority which empowers today? No. Do we have a granting patent office? No. We have a title? No. We don't. Obviously, we don't. That's very easy. Next question is, do we have a European patent system today? You always have told, I was vice president of the European Patent Office for 8 years, and I was talking about the European patent system. Julia, really? Do we have a European patent system, or we have half a system? Let's say we have, is there an authority that empowers in the European patent system? Well, yes, there are 38 authorities. Correct, yeah. We have a granting patent office and granting process, yes. Do we have a title? Is the European patent a title? I don't know, that's a tricky question. Is it a title? You know what happens when you don't validate in 3 months your European patent? You know what happens with this European patent? European patent disappears. So is this a title or is it a piece of paper?
At best, maybe a preliminary 3 months.
Preliminary? Can you have a preliminary title?
Perhaps not.
Well, I don't know. I just threw it to you. Is this a title? You need to validate, you know, yeah? You need to validate at least in one member state, not in the 38, to get a European patent validated in a given country. Please never say a European patent becomes a national patent. This is not true. The European patent is always a European patent, but as it is validated in Germany, in France, or in Austria, the effects are the effects of a patent in these countries, which is different, yeah? Except those effects will come directly from the European Patent Convention. Do we have autonomous effects? No, I told you, because the European patent validated in Germany will be ruled by German law, the European patent validated in Austria will be ruled by Austrian law. And do we have the power to enforce? No. So we don't have a European patent system as such. We have part of a system. We don't have time, but there is a reason for that, historical reason for that, which is very beautiful. If we have time and someone else, I will come to this. So, conclusion. Conclusion. Yeah? We don't have this, and we'll have that. So, after 53 years, something is moving. And this is why this becomes so fascinating. I will bring you to 1962. Well, mostly none of you have born when I was. In 2000 and in 2012. And let's see what happened. Because it's a funny conclusion. Oh, come on. Oh, come on. Yeah. No, again, no. Let's move. Okay, good, very good. In 1962, we have a first draft of community patent, which was declared by the European Commission confidential. See why? But after 50 years, every confidential gets public. So now we know it. You can find it in the internet. This first draft of community patent moved into a single European Union office. In those days, it was not called European Union, it was called European, meaning community, with a single granting system, a single title, autonomous and with unitary effect, and a court specialized in patents. Well, there was no agreement, but what we have is this. The question is, did we actually have a system here? What do you think? Apparently, yes. Yeah. Well, 1962. Well, then it moved to 1975, then 1989. Well, I will save you all this long path, moving right away to the year 2000, where there was already a legal basis in the treaty to move into a regulation. The year 2000, the regulation brought by the Commission understood, well, upside down. Understood that creating another patent granting authority in Europe made no sense. The EPO was working very well. It's still working very well. then it used the EPO and it granted system a subcontracted office for granting community patents. So the EPO had two tasks, let's say. Come to the EPO and you can, I want a European patent. And the EPO granted the European patent, classic EPO. You could come to the EPO up front asking for a community patent. And then you got a community patent. Yeah? Good. Single title, autonomous. So autonomous, you remember what it means, autonomous? The substantive law was in the regulation, all the rights and limitations, and a specialized court attached to the European Court of Justice was dealing with all the possible cases dealing with infringements and revocation. So, let's see. Do we have an authority which empowers? Yes, the European Union, sure. Good. Is this an authority? Of course. Do we have a granting patent office and a granting process? No, but this could be subcontracted. This is not an essential part of the system, as soon as you control what this subcontractor is doing. Did we have a title? Yes, community patent. Do you have an autonomous effect, a unitary effect? Yes. Did you have a court? Yes. So, was this a system? Yes or no? Well, apparently yes. Then it didn't work. And in 2013, and I save you all the details, we came with a package. What is a package?
Compromise.
Compromise on something which is consistent, in my view. If you talk about a package, you talk about something which fits. Okay, here we have a package. The package is composed by two pieces, and the two pieces are at a very different level. But it's a package. The package means two regulations and an agreement, an international agreement. What is a regulation? EU law. Why two? Because to come into an EU patent, the treaty, is 118 of the Treaty of the Functioning of the European Union, allows you to do it through qualified majority. You know what that means, qualified majority? Yeah? That's very essential for understanding how the EU works. Yeah? Qualified majority for getting the EU title. But what about the linguistic regime? Remember, if you want to bring all the members, all the languages of the European Union equally treated, you don't need unanimity. But if you want to establish differences, then you need unanimity. So you need two regulations, one through qualified majority, another one through special procedure, which is the Council, and then the Parliament is not co-acting, the Parliament is only giving advice. So then we have these two regulations, and we have, for the court, an agreement which is out of the system, completely out of the system. This is completely new. My dears, never before. What does it mean in practice? It means that we will use the EPO and its granting system as subcontracted office for the granted European patents. Yeah? Okay? Good. Exactly the same as in the year 2000. You remember? You remember this? Exactly the same? You're not very attentive, because you didn't react. You should have reacted. It's not the same. Look at this. Look at this. Look at this. Granting community patents. What is the difference? For granting European patents. Not the same. Which means that I will ask for a European patent, I will get a European patent, and then I have 1 month to ask for the unitary effects of this European patent. Because it could not be called EU patent. Because Spain and Italy were not there for the time being. So we don't have a single title. And not only that, we don't have autonomy because, as you remember, the basic articles substantive patent law were brought out of the regulation and brought into an international agreement. You like my accent? Yeah. Every time we talk in a language which is not ours, we should be allowed to have a certain accent.
I do have a Brazilian.
Good. Agora vamos falar brasileiro. So we have also this specialized court. Let's see, what does it mean? We got an agreement, but not all. Let's see, what do we have? Do we have an authority that empowers? Yes, we have a certain number of member states, 26 states, member states of the European Union behind. They say, we want this. So the answer is yes. Good start. Do we have a granting patent office in the granting process? No, it's the EPO. It doesn't matter. It goes, yeah? Do we have a title? Oh my dear. It's the European patent with unitary effect. So the unitary patent a title, I don't know. What is this? This is a European patent with unitary effect. What does it mean, unitary effect? Well, unitary effect means that in all the territory of the 26 member states, the effects are the same. What are these effects? Are they autonomous? Are they in the regulation? No. The effects are the effects we find outside. We find in an agreement. In this agreement, which created a unified patent court outside the EU, but we have to agree that there are courts. So, do we have a system? I just don't know, my dears. I just don't know. But this is a tricky question, and it's a fascinating question. Believe me. Is this a system? It's not a system. If I don't know what is a system, it's not a system. I'm not an actual jurist. So I have pain on my stomach. I am a jurist because I identify what a system is. A system. This is an elephant, and I see the elephant. That's an elephant. But when I see this, I don't know whether this is a system or not. I'm suffering so much. But it's a bit complex. Understand? Yeah. Understand this. Understand the situation. Understand? Well, that's what it is. It's fascinating. Is it, Julia? Is it? Yeah, it is. Well, is this possible end, or is it going to work out? I don't know. What I know, and this would be my conclusion, is that perhaps this is better than nothing. Perhaps we have to turn it into positive. Yeah. I'm not advocating for blowing the whole stuff. No. This is what's feasible. You look good, God. Well, let's see. Now the how. This is the how. Yeah. Obvious. So, what is really behind this? Could you still go a little bit? Yeah? Are you very tired? No? Good. Okay. So, these are the 4 very tricky issues. But you know them already because I came again and again to them. It's only 4. No way to unanimously agree a language regime. Correct? Yeah? Good. No trust in the European Court of Justice as competent court for dealing with infringement and revocations of EU patents. Many member states and also a lot of stakeholders move in the last years into the conclusion we don't want this Court of Justice dealing with private law matters. These judges about patent law. They have shown it daily with trademarks, and we don't want the same. So instead of that, we will create another institution where we will be sure that there will be really expert judges. But not only that, the third issue is no trust of the European Court of Justice as its capacity for interpretation, which is not the same as to apply. This, now we're talking about the autonomous leg. That's why at the very last minute, it was Mr. Cameron, basically, supported by others, or not opposed by others, let's say, who decided to suggest the Council and the Parliament to bring the issue back. the issue was so phenomenal, was so unique in the history of the European Union, that 29th of June 2012, the heads of state decided, first time ever, suggested that this should be put aside of the regulation, and 3 days later, 2nd of July, the European Parliament unanimously, no abstention, unanimously rejected this suggestion of the heads of state. First time ever, isn't it fantastic? Yeah. Well, but then time came, summer, and then after some months they surrendered. And finally, and this is important because this is me. For many people, for many stakeholders, and for many states, the key issue at the end was not the European patents with unitary effect, but the more than 500,000 European patents alive. Which means if you multiply by an average of 5-6 validations, this means 3 million patents which are now, which are now enforced. And in order to avoid the previous decision, Actavis Lilly, you remember, yeah, or Ronaldo's Messi, this court could have exclusive jurisdiction for dealing with all infringements and revocations of European patents with unitary effect or classic European patents. And this is a terrific added value, which brings the package a little bit curious, because the package is not dealing with the European Union, but basically the consequence is today the most important issue of the whole package is that this court will be exclusively competent to deal with infringements and revocations of European patents. My dears, first time ever, to my recollection, we have an international court dealing with private law matters so massively. The rules of procedure, which are now in its 17th draft, has 382 articles. This is phenomenal. I don't know whether you like private law. I do. It is the first time ever we have a body of procedural law complete. No room for moving into national laws. Absolutely complete from the very beginning till the end. This is phenomenal. And this is part of it. Glorious. So let's see what actually happened and what are the reasons for what I have told you. You know already everything, so just have a look. See, now we go smoothly until the end, it's very easy. The agreement requires unanimity. Spain and Italy oppose it. There's no possibility of having an EU title without the 28, so it could not be an EU title, so we come to the unitary. Yeah, correct? How? Through an enhanced cooperation process. You are learning quite an amount of different things here, yeah? Second reason, the member states participating in the package did not trust the European Court of Justice, so they prefer a court competent for both classic European patents and European patents with unitary effect. First time ever we have this in private law. Beautiful. Third reason, the member state did not trust the European Court of Justice for interpretation. That's why they gave out the autonomous effect, yeah? And they brought it into an international agreement. And fourth, the member states participating in the package decided that the Unified Patent Court had to be competent for both European patents with unitary effect and all sorts of European patents. Did I explain myself more or less correctly here? Yeah? You don't need to go into the details, you have to figure out that this is a fantastic topic to research and to develop and to go deep in if you really want to have a stomach as a jurist. These are the four reasons. How did Spain react? This. So Spain brought the Council twice to the Court of Justice. Nope. He should tell you why, but I thought that's it. First time, Spain attacked the decision which authorized the enhanced cooperation. And Spain failed. The Court of Justice said, no, it is possible an enhanced cooperation in this case. What was the main argument of Spain? Basically, the main argument of Spain the case was very interesting for many reasons. Please, this is a judgment, 16th of April 2013, and this is a key judgment, not only for IP. Yeah? The judgment says, first time ever, it is possible an enhanced cooperation when there is a clash. Why? Because the treaty, as it is now in the Lisbon text, does not say specifically that whatever state can oppose to the enhanced cooperation, which was the case in Amsterdam. So the court took a literal interpretation of the treaty and say, as the treaty does not say anything, enhanced cooperation is open to any situation. Important. Spain said, no, the spirit of the enhanced cooperation is not this one. Enhanced cooperation should not be allowed in these cases. What we need is an EU panel. So let's continue trying to find an agreement. Okay, well, Spain, okay, what is this? Then this decision brought into two regulations. In an enhanced cooperation, you have a council decision authorizing you to do something. Do you know what the authorization said? Very easy. The authorization said, please bring into practice, into life, an EU patent. But they couldn't. They came with a European patent with unitary effect. So Spain came right away and said, this is not a European Union patent. You are not using the legal basis. You are not using Article 118, and you cannot use any other legal basis because there's a specific legal basis for that. So either you bring an actual EU patent or nothing. Some end of November, 17th of November, I think the Advocate General, French by the way, the Advocate General just advised the Court of Justice to dismiss completely the exercise, and the Court of Justice will give a beautiful judgment, I guess, in some weeks or some months. Not easy. Very two interesting cases. I don't want to forget, the very first case has a key issue, which was not asked, but sometimes the Court of Justice entered into very tricky paths. Issue was, what is intellectual property? Judgment 16th of April 2013. Is intellectual property related to the internal market? Or intellectual property is competition? My dears, I started with this business many years ago, and I was told you have a competition system, and within the competition system, you allow certain exceptions for certain reasons. But this is part of the competition system. This is not against the competition system. This is part of competition law. Having said that, you need an EU patent and a EU patent system in order to achieve the internal market and not to create differences among the different member states. Does not make sense that a European patent is validated in Spain and is not validated in Germany. This distorts the internal market. One thing is distorting the internal market. Another thing is belonging to. Okay, the Court of Justice said that the intellectual property is part of the internal market. The issue is relevant because the internal market is shared competence, while competition is exclusive competence. And you cannot have enhanced cooperation within the framework of exclusive competence. But you can have enhanced cooperation without the framework of the internal achievement of the internal market. See the point? Good. So let's see in the third act, last one, why this is so fascinating. We'll go quick because you know already so much. I'm going to give you 11 reasons why, for further consideration to you. Yeah? 11 reasons why I'm in love with this. And this gives you ammunition for so beautiful thinking again and again outside the patent system, and probably at the end the patent system is the less relevant issue here, but the law. Let's go. It creates a package. This is new. The package deals with two very, very different issues, yeah? Correct? Fascinating, yeah? Look at it. Pears and apples. European patent with unitary effect and a court, exclusive competence for all sorts of European patents. Good. That's new. This is completely new. Fascinating. Second, because it creates for the first time ever an international court having competence. I've said to you so many times, but for me this is so extraordinary. I do hope you're very young. You will have the opportunity of seeing other cases, but this is the only one perspective. Private law ruled and enforced by an international court. Here they are. That's new. This is completely new. Number 3, and this is something new, because this court is a minotaur. This court is an international court and a national court. How is this possible? Did you know something like that before? No, it didn't. But this is an international court and a national court. Look at this is the Article 1 of the UPC agreement. Subject to the same obligations under union law as any national court. Not only this international court, and this is what is absolutely fantastic, and I wonder one day if this comes to the Constitutional Court in Germany, what's going to happen. This court is part of the judicial power of all the different member states which have ratified this agreement. Which means that it is a German court, it is a Belgian court, it is a British court, and it is a Lithuanian court. National court. Which means that a judgment rendered by the Central Division in London with 3 people in biotech, in pharma, with 3 people. One is a Latvian engineer, another one is a Slovenian lawyer, and another one is a Maltese lawyer, running the case in German. This judgment will be a Belgian judgment, a Danish judgment, and a Swedish judgment. I have never seen this before. This is an incredible imagination, innovative improvement in law, which I don't know how it's going to be to fit, but it is like that. You know why? There is a reason for that. The reason is that the Court of Justice put the finger into previous drafts saying, listen. You can be outside. I cannot avoid that you are outside the EU law, this unified patent court. But you are going to apply EU law because all you member states are EU member states. As soon as you are going to apply EU law, you know who is the only body who can interpret EU law? Myself. So if you are an international body, you will not be able, through the treaty, you will not be able to ask me questions for the interpretation. So I will be impeded to interpret the EU law. So either you are a national body, either you are a national court, or the whole system goes down. So the answer of our clever politicians was to say, well, let's put it a national body, that's all. So this is a national body. There's another beautiful consequence of having a judgment which is run by an international court. Obviously this is an international court, but at the same time it's a national court in any other, in all the member states. Did you heard about the Brussels regulation of jurisdiction and execution of judgments, or enforcement of judgments? you have a UK judgment, and you want to recognize and enforce this judgment in Germany, you do it through this regulation. This is not a German judgment, it's a British judgment, which is recognized mostly automatically in Germany. Correct? But this is not the case, because this is a German case. Actually, this is a German judgment. So, the judgment has two pieces: the content of the judgment and the order of execution. And the order of execution goes to the enforcement procedures, the national enforcement procedures, directly like any other national judgment, because it's a national judgment. Wow. This is a miracle. Yeah. First time ever. That's new, my dears. Europe is imagination and innovation, you see? The structure of the court is very complex, but that's not the point. We will not go to the structure of the court. Say that distribution of competence is really diabolic, yeah? Absolutely diabolic, but it is. Probably there was no other way of doing this. The decisions of the court forms integral part of all and each national judicial system. It's incredible, yeah? This is a miracle. Miracles still happen. It is a miracle. Yeah? It is an ubiquitous. They say, what is this judgment? The judgment is an ubiquitous judgment. That's new. I'm not judging. I'm not contesting. I'm saying this opens a terrific amount of questions for the jurist. That's why you're here. 6, because it deals not only with European patents, but also with classic European patents. So this poses a problem, Henrik, which I don't have an answer. Imagine that I come and I go to this court and I ask for the infringement of a European patent validated in Germany. It's fine? Yeah? What I am asking for? The infringement of European patent validated in Germany. Now I also have realized that my patent is also infringed in Spain and in France, where it is also validated. So I will ask the court in one shot for the infringement damages and so on of the European patent validated in Germany, in France, and in Spain. That's correct. Or not? Spain is not. So Spain out. Okay, first thing. Second, is this correct? I'm asking for the infringement of a European patent validated in 2 places. Or I'm asking for the infringement of a European patent. I don't know. Theoretically, the title is when I validate it. This is the title. So, I have to ask theoretically for the infringement in a given place, in another place, and in another place. But the court is always the same. So, if the court is always the same, as a lawyer, I will ask for the whole infringement. It's the same price, let's say. It's the same court. If later on I go to the infringement in France, I have to come out to the same court. The same decisions. Imagine that what I am asking now is for the revocation of the European patent validated in Germany and validated in France. I'm asking for the revocation of a European patent validated in, as today, or I'm asking for the revocation of a European patent. When this court will revoke the patent, it's revoked in a given state, or it's revoked for all the states? Not easy. Not easy especially, and I don't want to go further than that, because during the transitional period, we will have the national courts also competent, perhaps for 14 years. And national courts are not allowed to declare the revocation of a European patent, but the European patent validated in. You see? Beautiful. Never ever before this sort of problems. So, that's it. That's new. The package was adopted through enhanced cooperation. Completely new. Beautiful. The regulation established a linguistic regime, but at the end, if you realize the linguistic regime is a non-linguistic regime, you come to an end. Because what the regulation says is there is no linguistic regime. The linguistic regime is the regime of the European Patent Office. Why did Spain oppose it? Why did Spain oppose? Or Italy? Because they said, well, when I joined the European Patent Organization, I committed to run the procedure of a European patent in French, English, and German. I committed that there should be a translation of the claims of the other two languages, but the language of the patent. But when it comes to me, I request the translation, full translation. This is the present business, regardless of what you like now. This is what it is. Now we have the London Protocol changing things, but this is what it is. And then Spain and Italy said, that's different. Now I have to swallow patent granted by the Unified Patent Court in German without any sort of translation. I'm not contesting, I'm saying it's different. So in fact, the linguistic regime is a non-linguistic regime. In fact, what we have, and this is also something interesting, is two empty shells. First time ever. Believe me, Lionel, I have read thousands of regulations. I have written many. I never found an empty shell. Are you interested in EU law? Yes. Can a regulation be an empty shell? Can a regulation be with no contents? Finally, what is the main contents of the first regulation? A body of law, substantive body of law, and this was taken out. So when you see what is this regulation which created the unitary effects, the regulation says there will be unitary effects. That's it. The rest is, let's say, is given to the European Patent Office some clerical work, and that's it. Yeah?
Exhaustion.
Exhaustion is something which is in, I wouldn't say 150, but at least 25 relevant judgments of the Court of Justice. So this is something which is
Clear.
absolutely clear. You take this article out and nothing happens. I didn't see anything really, anything with contents. When you go to the other regulation, the linguistic regime, you find the linguistic regime is basically a non-linguistic regime, except some transitional period. Is it possible to have regulations which are empty of contents? Beautiful. The legal basis is Article 118, but 118 says you have this legal basis to create an EU title. Is this an EU title?
No.
Well, you know how to obtain now the unitary effects. This is a new title. So you have a classic European patent, then you have 1 month for asking, and then you register the European, you register the effect. So this is new. Spain stays out, which is not very important, but well, stays out, both, yeah? File this first judgment, this first case, then the second case, as I explained you, they were there. That's it. That's it, yeah. And finally, I've never found a case which I tried to develop in more time than what I expected, and thank you very much for being so patient with me. But this is absolutely fascinating. This shows that we move into an intergovernmental era. And that's it. And probably we have to accept it, regardless whether we like or not. And this is very important for our training, our legal training. So now we go to the epilogue, yeah? If you're still able to do this. You agree with this? I think we still do this. I've been fighting for that for 10 years. I'm not saying what has come about is wrong. I say it's not this. We don't have an EU patent system. So we don't have the European Commission having exclusive competence to organize and to design the whole strategy. What we have is different sensibilities. In fact, what I have tried to develop here is the four approaches. Let's say I come with the idealistic approach, wrong, yeah, didn't fit. Then a critical approach, the other extreme, yeah, we don't need an EU patent system. Then a pragmatic approach, well, it's better to have the system or the so-called system in most of the member states, not in all. It's better to have unitary effects, even if we don't have autonomous effects. And it's better than nothing to have the all outside and not inside. And then finally, there is also a realistic approach, yeah? Which says that, in fact, the whole issue of the EU patent has to be forgotten. People are not going to use this unitary patent or European patent with unitary effect. What really matters here is that first time ever, we have international court with exclusive competence for infringement and revocation of European patents, and this is what matters. Conclusion number 3 is that this enhanced cooperation is absolutely unique in the history of international organizations. And this has a lot of merit per se. And finally, this is a key relevant case for the movement from the European Union to Europe. Final conclusion, is this a failure or this is an opportunity? Well, I think it's both. It's a failure because it's not what it was promised. You know a lot about that. But it is an opportunity finally. It is first time ever we have a European patent with unitary effect and we have a unified patent court. But most of all, my final conclusion, this is a fantastic opportunity for you. Take this case as a test case. Don't abandon it. Try to go deep. The last word is not yet pronounced. It's the Court of Justice coming. It's still the process to bring the whole issue into life. But this is, I started by saying that in 30 years of practice dealing with law, I've never seen a case like that. That's why I devoted more than 1 hour, I'm sorry for that, to try to convince you that this is fascinating. Go deep on that, please. Thank you.